Good evening, everyone. Welcome to our Women and Wills webinar. We'll take just a moment to allow all the guests to enter the room. Once again, welcome to tonight's event, Women and Wills Estate Plan Decision Making, featuring our guest speaker, Joanne Johnson. I'm Maria Howell, a proud member of Davidson's class of 1991, a parent to a student in the class of 2025, a sister of a class of 1989 alumna, and the daughter of a class of 1957 alumnus. After leading the Office of Alumni and Family Engagement for over a decade, I've spent the past few years working in our development office. I'm excited to share that I now have the privilege of leading Davidson's women's philanthropy effort as part of our new initiative, Women Act. It's my pleasure to co-host this evening's event with my colleague, Jamie Stamey, the director of the Office of Gift Planning, who will manage the Q&A with Joanne later and provide some closing remarks. Women Act is a new initiative at Davidson College that brings women together to create a lasting shared impact on Davidson students' experience. ACT stands for Aspire, Create, and Transform, reflecting our mission to aspire to make a difference for Davidson, create new opportunities and pathways to transform student experiences, and how our graduates lead and serve in the world. In our inaugural year, we received support from more than 425 alums for the newly established Wildcat Women Fund, which will support student health and well-being efforts on campus this year. In total, women made up more than 13 million of leadership gifts to the college. It's been extraordinary to see women step up and lead at Davidson. When we launched Women Act last November, we heard loud and clear from many alumni that educational opportunities were a priority. That's why we're especially excited to host tonight's event during National Estate Planning Awareness Week. This webinar is an opportunity for us to come together and learn how to make informed decisions about our estates and the legacies we wish to leave, whether that means supporting our families or charitable organizations close to our hearts. We're thrilled by the response to this event and look forward to offering more educational programming in the months to come. As you've likely heard, women are expected to inherit a significant portion of the estimated $68 trillion in wealth being passed down from baby boomers. This is according to research by McKinsey. We want to ensure that our alumni, parents, and friends are knowledgeable and prepared as they think about the future. We're delighted tonight to be joined by Joanne Johnson. She's a current Davidson parent. I will share more about her in a moment, but I wanted to take this opportunity to thank her for raising her hand and for so quickly engaging with the Davidson community. Before we dive in, a few housekeeping items. First, we are recording tonight's webinar so that we may share it with those who are unable to attend. Additionally, we will send both the recording and Joanne's presentation to you after the event, so no need to take photos of your screen. You can just sit back and listen. We'll have time for Q&A towards the end, so if questions arise during Joanne's presentation, please submit them in the Q&A box. You'll see it with a little question mark down there, and we'll answer as many as we can get to. Now to introduce our speaker. We're very pleased to welcome Joanne E. Johnson, who is a managing director and senior wealth advisor for the J.P. Morgan U.S. Private Bank. Previously, she worked for J.P. Morgan as the head of the U.S. Private Bank Wealth Advisory Group and the Trusts and Estates Group, the head of the law firm group, and senior wealth advisor in the Northeast. Joanne specializes in developing strategies for holding, managing, and transferring wealth tax efficiently and across generations for the firm's ultra-high net worth clients. Joanne is a frequent lecturer and author on estate planning, estate administration, and wealth management issues. She is a regularly quoted source to financial publications and a repeat guest on various news outlets. We feel so fortunate to have her with us tonight. Joanne received her BA from Trinity College, which is in Hartford, Connecticut, and her JD from St. John's University School of Law. She resides in Bronxville with her husband and has twins. Her daughter is a Wildcat in the class of 2028. And if you're quick at math, you'll note that that means that she's a first-year student. And her son is a Demon Deacon. Please join me in welcoming Joanne.
Maria, thank you so much for that warm Wildcat welcome. And it is truly my pleasure to be here. And I have a little quiz for everybody who's listening today. What do these people have in common? Jimi Hendrix, Bob Marley, Howard Hughes, Sonny Bono, Pablo Picasso, Abe Lincoln, and Prince. Yes, they're all famous men and a seemingly disparate group. The one thing they have in common is each one of them died without having a valid will. This led, in many of these cases, to false claims, decades of untangling heirs at law, and prolonged administration and tax controversy. Perhaps the greatest tragedy here is their intentions were not expressed, nor were they carried out. The expression of your intentions should not be limited solely to the disposition of your wealth. It has to extend also to your own intentions for healthcare should you not be able to communicate. For those of you who remember the sad case of Terri Schiavo, you know that the expressions of intent regarding healthcare is critical. Terri was a 25-year-old woman who suffered cardiac arrest and was unable to communicate. She did not have a living will, nor did she have a healthcare proxy appointed to speak for her. And what happened is her husband and her parents disagreed about her care and her treatment, and they fought each other in the courts for decades over whether or not to remove her feeding tube. These famous people are not just known for their accomplishments. They're also known as people who neglected to take the necessary steps to express intentions about families, wealth and its destination, healthcare decisions. These incidents can be avoided by simply acting, taking control of your destiny through strategic use of documentation and later planning and governance. Tonight is an opportunity to explore the methodology to enable you to identify the decisions you need to take to control these aspects of everyday life and the intentions we have for the impact we're going to make by using the power we have of our wealth. Why don't we move to the next slide? And number 3, please. Thank you. Estate planning is the process of preparing to transfer in a very orderly manner one's wealth, whether it's a transfer during lifetime or upon passing. It can be outright, directly to an individual, or you can transfer your wealth in trust, held for the benefit of intended recipients. In both cases, thoughtful planning has to ensure that wealth is transferred to intended recipients at the intended time with predictable tax consequences. A critical component of planning is the appointment of appropriate entities and/or persons to oversee the prudent management of one's affairs and assets. Let's move to slide 4. Let's take a moment to review the components of a sound estate plan. There are items you need to attend to, and then there are items that are nice to have. Tonight, we're going to focus our discussion on the necessary elements. First of all, every state has laws governing the aspects of wealth planning and transfer of those laws, and they differ from state to state. I'm going to speak in generalities and generally refer to federal tax law, and your attorney should advise you on particular local law issues. Often, when people open a bank account, an investment management account, or a brokerage account, they focus only on how they will use the money or how the money can work for them by making impactful investment decisions. The titling of the account is often an afterthought. Please don't make that mistake. Improper titling that is inconsistent with your estate plan and your intentions for how your wealth is going to be held will thwart your intentions. For example, if under your will, you bequeath your will to your surviving spouse in the form of a trust for their benefit, but you title your assets in a joint account with your spouse with a right of survivorship, the terms of that account control. In other words, the assets don't come back into the hands of your executor to be passed under your will and fund that trust for your spouse. Your spouse will inherit those assets outright. So inconsistent titling results in a completely different result. The same admonition is going to apply to beneficiary designations. And then when I think of beneficiary designations, I think of what we sign when we take out a life insurance policy or a retirement account. If they are not consistent with your intentions in your overall plan, they too will control the destination of that wealth and any intention you have written into your will with respect to those accounts will not be effective. And as I mentioned in opening, thoughtful planning is not just limited to financial assets. Planning includes making decisions for the guardianship of your minor children in the event of your passing. Typically, those directives are made in your will. Be very thoughtful, though, as time passes. Personal circumstances change, and these important designations require review and revision. Since we're not going to spend a significant time on retirement planning, I've included some slides in this presentation in the appendix on retirement account contribution levels and on beneficiary designations. Unless a retirement account beneficiary is a surviving spouse, those accounts become the most heavily taxed in an estate because those accounts are subject to income tax, federal estate tax, and in the case of states that have state-level estate taxes, they will have a third tax. The practical and discouraging result is that if you designate your children as the ultimate beneficiaries upon the passing of the surviving spouse, the after-tax amount that your children will inherit is roughly 30% of the value of that account. And given legislation that was recently passed, the Secure Act 2.0, the money must be pulled out of that account within 10 years. Inherited IRAs must be paid out within 10 years. So the impact of that IRA is greatly muted. And for those reasons, many people designate Davidson as the IRA beneficiary upon the passing of a surviving spouse, because your estate is going to receive a charitable deduction against estate tax of 100% of the value of those assets. And Davidson receives 100% of those assets and does not pay any income tax on the assets it receives. But without a doubt, the most important component of your estate planning begins with the creation of a will and or a revocable trust. Let's move to the next slide, please. Pablo Picasso famously said, "Only put off until tomorrow what you are willing to die having left undone." Ironically and disastrously, because of his deep superstitions, what he put off doing was creating and signing a will. His vast fortune, including 45,000 pieces of art, valuable real estate in different countries, and great financial wealth, was left to be administered pursuant to law. In other words, it's what we know as intestacy. And that distribution of wealth was not governed by his intentions. That intestacy, in his case, was made even more disastrous and chaotic because of his numerous children, wives, ex-wives, and lovers who survived him. It took 6 years of litigation just to have his son appointed to administer his estate. Nothing could be done to sell the estate during those 6 years, and his son spent 3 decades administering that estate. To say it was complicated and completely chaotic is an understatement. Now, that's an extreme example, but I put it out there to let you know that making the decision to move forward to document your intentions is critical. People have a lot of reasons not to move forward. They are concerned about mortality, the fear of relinquishing property, and the fear of losing control. In reality, writing a will actually prevents what is feared. The will sets forth your intention of how your assets are going to be disposed upon your passing. It's going to identify your heirs. It's going to appoint individuals or entities or both responsible for carrying out your wishes. Those fiduciaries are executors of your will, responsible for administering your estate, and or trustees of continuing trusts that you may create under your will or revocable trust. Guardians of your minor children will be appointed, and I can't emphasize how important this is. That also is not something you want left to chance. There are important issues for consideration when you start thinking about making your will. Who's going to receive the wealth? Who's going to be the executor and trustee? What tax elections and optimization to minimize tax are you willing to take, and what will you put in the hands of your executor to make decisions about? When the beneficiaries should receive assets, at what time and in what form? Are you leaving it outright in trust for them? Will they get it at certain ages? Most important, without valid documentation, who will inherit your wealth when state law dictates the outcomes? If you have intended for assets to be bequeathed to specific individuals or to a specific fund or purpose at Davidson, it's not going to happen. Now, I've mentioned the role of an executor. The person or entity, typically that's a trust company, that you appoint has substantial responsibility. They have the duty to manage all aspects of the estate in a non-conflicted, independent, and consistent process. Selecting those people or entities is an extremely important decision, and it's going to make a difference about the outcomes and whether or not your intentions will be effectuated flawlessly. Let's review the role of an executor. So let's go to the next slide, please. On page 6, please. Thank you. So the executor is the person or entity responsible for settling the estate of a deceased person. There are numerous roles and responsibilities that I've broken out on this slide. The tasks that are listed are by no means inclusive of all potential responsibilities. When I work with clients, I pull out a long sheet of responsibilities and estate administration tasks. The complexity is often enhanced because of asset mix, family circumstances, and the organization of a decedent's affairs. Generally speaking, the executor first marshals, which means gathers all the assets, inventories and values those assets, and secures, insures, and protects the values of those assets. Your executor is going to wear a lot of hats. The assets have to be invested appropriately. First, the executor identifies the cash requirements of the estate: debts, taxes, expenses, cash bequests. The executor must raise the cash immediately so that those requirements can be met, and there's no risk that assets will decrease in value so that the cash might not be available to meet those expenses. And just so you all know the timeline, the federal estate tax return that would be filed for an estate is due 9 months after passing. And that's when the estate taxes would have to be paid. The balance of the assets that are not in cash will be invested prudently. No speculation, no heavy risk assets. The executor is responsible for preserving wealth. This is not where you swing for the fences. The executor also has to oversee court proceedings and must file for the probate of the will to validate the legitimacy of it. Probate in Latin means to prove, and the process proves that the will was made without duress, undue influence, and that the testator was competent to make a will. A will contest, where a person who may have inherited assets under the intestacy laws and challenges the provisions of the will, are defended by the nominated executor. The executor also has responsibility for record keeping, bookkeeping, tax compliance, both from an income tax perspective, because an estate becomes its own income taxpayer, and the estate tax. And as I mentioned, the payment of any debts, taxes, and ultimately the bequests and the distribution of all the assets are made by the executor. This is just a cursory review of these responsibilities. I urge you to speak with the person you are considering appointing. It is not just an honor to entrust someone with this responsibility. This is a full-time job. It's extremely time-consuming. It requires certain skills, and it requires the ability to communicate very effectively with your beneficiaries. It comes with compensation, but it also comes with potential liability. So open communication and a thoughtful consideration of whom it is that is going to assume this role is imperative. Can we go to the next slide, please? Thank you. We've already reviewed a very colorful example of intestacy, a person who dies without a will. Please remember, the law of the state in which you are domiciled will control who receives your assets if you die intestate. And I should also remind you that most states say that the age of 18 is the age of majority. So if you don't have a will and your assets are passing by intestacy and you have minor children, they may be inheriting a significant amount of wealth, unfeathered, without guardrails, without control at age 18. I have two 19-year-olds. That is not a risk I was willing to take. Let's go to the next page, please. Now, I've mentioned the word revocable trusts, and on the need to do slide, it appeared alongside the word will. That's because a revocable trust essentially can be a will substitute. Now, I know I'm saying your will is the most important thing you're going to ever do, that the most important document you're going to create. The revocable trust has equal importance, and it's an enhancement to a standalone will. It is a governance document. It is not for tax planning, current or future. It accomplishes several things. It serves as a vehicle to manage your affairs should you become incapacitated, and it can serve as the entity that is used for estate administration. It can protect you during your life and continues to carry out your intentions for your wealth when you're gone without interruption. Here's how it works. You're the grantor, the person who creates and funds a trust. And you create this trust, you name the trustee, and the trustee will be yourself. And you will be the beneficiary and the sole beneficiary during your life. You fund the trust with the majority of your assets, both financial and tangible. That means you change the account titling of everything you own. Remember, account titling is critical. You serve as sole trustee. You have the power to invest, to sell, to withdraw, to spend, to terminate. It is your money. And you file your income tax returns just as you do today. You use your Social Security number as the tax ID number for the revocable trust. Here are the benefits. If you become incapacitated or you age and are no longer able to manage your affairs, your successor trustee who is named in the document automatically takes responsibility. What I often counsel my clients to do is have a provision that says that upon the certification of 2 physicians that you can no longer manage your affairs, the successor trustee then assumes responsibility. There's got to be some kind of independent mechanism to trigger that change in control. And that is a very good way to prevent fraud, theft, or undue influence. Upon your passing, the trust assets will continue to be administered, invested, and it becomes your estate. Your successor trustee or somebody else or an entity that you name becomes responsible for estate administration. The trust is then irrevocable and cannot be changed. Now, you still need a will because not every asset is going to be funded in this trust. So you may have to go through probate. That will, you might hear the words, it's referred to as a pour over will, because anything that is subject to probate through that will pour over into the revocable trust, and it will be disposed of pursuant to the terms of that revocable trust. This mechanism avoids probate. Now, why is that important? Well, for two reasons. One, probate is a public process, and your will becomes a matter of public record. If you are looking to have privacy element to your estate plan, the revocable trust is the vehicle that you can use because its terms and provisions are not made public. Perhaps very importantly is understanding that if you only have a will, when you pass away, your assets are frozen. Your financial assets are frozen. They cannot be managed until your will is admitted to probate. Now, there is a proceeding in many states that allows you to get a preliminary granting of authority to a preliminary executor, and that allows some administration. And then the formal letters would be issued when the will was finally officially admitted to probate. However, what happened during COVID really taught us all a lesson. The courts were closed. There were no probate proceedings. And you all know what was happening. People needed their wills to be admitted to probate, and it wasn't happening, and all these assets were frozen. The assets in a revocable trust, and those clients of mine who had funded revocable trust did not have their assets frozen. So more and more often, the combination of this pour over will and revocable trust are considered a best practice in the industry. Now remember, asset titling makes the difference. And if you don't retitle the assets in the name of your revocable trust, this doesn't work. Let's go to the next slide, please. A power of attorney is used in the event of your incapacity or in circumstances when you want to empower someone to have specified authorities. A durable power attorney is really intended for when you're not able to make decisions on your own. When you're not able to make decisions on your own, and you're appointing someone to act in your stead. The power of attorney terminates upon your passing. A power of attorney can be for a specific purpose. For example, if you have a child who is an expert in investing, you may sign a power of attorney over accounts to that child. Let's go to the next slide, please. We talked a little bit about living wills and healthcare proxies. They are critical, and with the use of portals and hospitals, you give your doctors copies of this, you give your local hospitals copies of this. The best advice I can give you is only appoint one person to have authority to make decisions if you're not able to communicate. If you have two people acting jointly and one cannot be found, and it's a matter of great urgency, it's going to be very, very difficult. And just as a little public service announcement, if you have children who are 18, please make sure that they execute living wills. They give you their healthcare proxy and the powers of attorney. My family used Mama Bear legal documents. It's all online. You would obtain state-specific forms and to develop a full suite of necessary documents. Let's go to page 11. Now, our discussion is focusing on what tools and strategies to use to effectuate the intent for your wealth. and how to control outcomes. And good governance and adherence to process will benefit you and the persons and the entities that you care about. Now, to have a valid trust, 4 things must be present. A person or an entity must create the trust. That person is the grantor, the settlor, or the trustor. There must be a written trust agreement stating that the purposes of the trust and who benefits from it. Assets must be funded to the trust, and you need a trustee. You can create a trust during your lifetime. That's an inter vivos trust. Or the trusts for the benefit of other people can be created under your will or revocable trust. That's referred to as testamentary trusts. Revocable trusts are subject to the claims of your creditors. A trust may be irrevocable, and it can be written so that assets are protected from the creditors of the grantor and the creditors of the beneficiaries of the trust. A trust can be its own taxpayer, or the trust can be structured so the grantor pays all the tax liability on the activity in the trust, thus making the trust a tax-free entity for growth. And it's like making another gift to that trust when you pay the taxes on it. Why don't we go to the next slide, please? Trusts are used to transfer assets off your balance sheet to reduce estate taxes. You move principal and the appreciation thereon to an entity, thereby removing those assets from your taxable estate. As I mentioned, they can be structured to be asset protected. You can create a trust to benefit specified people at certain times and in certain amounts. You control when they receive these assets. You can use it as motivational to perpetuate your values, to provide education, to give complete professional and vocational freedom by specifying that assets can be used to enhance lifestyle for those selecting to pursue careers that are less lucrative than others. They can be written in certain jurisdictions so that they are what we call silent. The beneficiary need not know about the existence of the trust until you are ready to tell them or you specify a date. Let's go to the next slide, please. Your intentions, actually, let's go to page 14. Thank you. Your intentions and goals for your family and the entities you want to benefit will come to fruition if the trusts are properly administered. The choice of your trustee is critical, just like the choice of your executor. And the duties of the trustees are, 1, to determine an asset allocation for the investments that are going to balance the interests of the people who receive income and the people who will ultimately receive the principal of the trust. They have to follow investment prudence, including diversifying and investing for total return. They have to manage special assets. You may have art in there, collectibles, private business interests. They have to exercise discretion over distributions if you're not specifying a specific amount. They must communicate with beneficiaries, and they must perform all tax compliance, including filing annual income tax returns. They are the most powerful and effective way to transfer wealth tax efficiently and managed to fulfill intentions and to benefit the people that you care about, as well as entities such as Davidson. Let's go to the next slide, please. Let's go to page 16. Now, let's take a few minutes to identify what we have talked about, which is the issues requiring your consideration and decision-making. Your intentions for how your wealth should be used, accessed, and distributed need to be clearly and unambiguously expressed. You need to carefully consider which people who would be recipients of your wealth and how you want them to receive that wealth. Proper titling of your financial assets. But the decision tree for the movement of your wealth is actually very simple, as you see on this slide. Your wealth can only go to one of 4 places. You spend it, you give it to family and friends, you donate it to Davidson, or you engage in what I call involuntary philanthropy. You pay taxes and the government spends it for you. Once you decide how you want to divide the power and use of your wealth among those four buckets, you need to determine how to achieve that tax effectively. There is a tax impact to every decision that you make regarding the use and transfer of your wealth. So in addition to all the decisions we have enumerated that you can make, we need to become familiar with the tax impact of those decisions. So let's go to the next slide, please. So the federal estate tax was first enacted in 1797. It was repealed, reinstated at various times, and it has been in effect continuously since 1916. Income tax became law in 1862 when Abe Lincoln signed it into effect to help pay for the Civil War. Given the applicability of both tax regimes in 2024 and the impact they have upon the decisions that you're going to be making about how you unlock the power of that wealth, both for your personal use and for the legacy that you intend to leave, it's imperative you understand the basics of the transfer tax system. I'm sure you all have too much familiarity with the income tax system. We're not going to spend a lot of time on that, except to remind you that estates are also separate income tax paying entities, as are irrevocable non-grantor trusts. Transfer taxes refer to both gift and estate taxes. Any amounts of wealth, regardless of what form they take, tangible property, cash, equities, your real estate, any amount of wealth that you transfer to another person is a gift that may be subject to U.S. gift tax. There's only one state among 50 that has a gift tax regime, and that's Connecticut. Every other state does not impose a gift tax. Please note that any amounts that you transfer to your spouse, either during your lifetime or at your passing, whether it's outright to your spouse or in further trust, and that trust is subject to certain conditions, will be free of gift or estate tax because it is covered in what is known as the unlimited marital deduction. That makes transfers between spouses transfer tax deferred. And I say deferred and not tax-free because upon the passing of the surviving spouse, there's going to be estate tax due on those assets. Unless they remarry and you've left them your estate outright, and then they leave their money to their surviving spouse, or perhaps they make a gift to Davidson and that qualifies for an unlimited charitable deduction. Gift tax is payable by the donor, and the tax rate is 40%, and it's based on the fair market value of the asset or the gift that you are giving. Now, there are certain ways you can make gifts that do not incur gift tax. If you pay medical expenses directly to a healthcare provider for the benefit of somebody, there is no gift tax payable on that, but it has to be directly from you to the doctor, the hospital, the clinic, the orthodontist, whatever healthcare provider it is. It can't go to that person and the person turns around and pays their doctor. Same thing about gifts of tuition. You can pay for tuition to any educational institution from preschool all the way up to graduate school, but it needs to be paid directly to the educational institution. Every taxpayer has the ability to gift $18,000 per year to any number of people. That is known as the annual exclusion from gift tax, and that amount is indexed every year. It's scheduled to increase to $19,000 on January 1st, 2025. You can use annual exclusion gifts to fund college plans, the 529 plans, and you can front load up to 5 years total of annual exclusions into that 529 plan and get it growing tax-free and compounding in that amazing way. You cannot then use that $18,000, soon to be $19,000 for the benefit of those children until those 5 years have passed, and then you could use it again. Now, over and above those exclusions is a significant exemption from gift tax. Every person has a lifetime exemption from gift tax of $13,610,000. That is scheduled to increase to $13,990,000 on January 1st, 2025. A married couple can therefore protect approximately $28 million from gift tax. However, under current law, that amount is scheduled to decrease to approximately $7 million per taxpayer on January 1st, 2026. To the extent not used, those exemptions from gift tax will apply to your estate tax liability. The federal estate tax is imposed on all assets you own, including assets held in your revocable trust, upon your death. The top rate, like gift tax, is 40%. However, many states have state-level estate tax or inheritance taxes. For example, in New York, the net effective rate often exceeds 50% when combined with the federal rate. Estate tax is generally paid from the residuary estate of its decedent, unless there's specific direction in the will or revocable trust to apportion the tax among beneficiaries who are receiving specific amounts or assets under the will or the rev trust. Gift and estate tax laws affect the cost basis that your beneficiaries receive when you give money or assets to them. If someone inherits assets from your estate, they receive what is known as a step-up in basis equal to the fair market value of the asset that was valued as of the date of passing, the date of death. For example, if I bought an asset for $100 and it's valued at $1,000 at my date of death, and I bequeath that asset to my child, the new cost basis in that asset is $1,000. So that child, if he or she goes and sells that asset, right away, they're not going to pay capital gains tax on it. That's different than the cost basis treatment for a gift you make during your lifetime. If I give that same asset that I've paid $100 for to my child, their cost basis in that is $100, even though it's worth $1,000 when I've transferred it to them. So they now have a capital gain, a long-term capital gain of $900 on that asset. That is called a carryover basis. Having a working knowledge of these concepts is going to help when you consider what types of assets to use for gifting during your life. Generally speaking, low-cost basis assets are not the best because there's an inherent liability attached to them. What's best is cash, assets that are going to appreciate in value in the hands of the recipient or the trust that you're transferring it to, assets that perhaps are discountable in value, such as a private company stock or partnerships. Finally, I want to briefly mention that the unlimited marital deduction is not available for lifetime gifts or testamentary bequests to non-U.S. citizen spouses unless assets are bequeathed to a specific trust for a non-citizen spouse that's called a qualified domestic trust, or you make a lifetime gift and that gift is limited to $185,000 annually. Let's go to slide 20, please. Now, there's a third tax you should be aware of, and that's called the generation skipping tax. It's effective when you transfer assets to a grandchild or someone who's 37 and a half years younger than you. It's the same 40% rate as the other taxes, but it's not connected to the gift or estate tax calculation. It's a separate tax. So if you give $1 to a grandchild, you owe 80 cents in tax. That's your gift tax of 40 cents and your generation skipping tax of another 40 cents. However, there's an exemption against that tax. It's the same $13,610,000, and it's going to be increased and then decreased in the same way that the gift tax and estate tax exemptions are being decreased. When you make your annual exemption gifts, your $18,000, that is free from generation skipping tax. What I have found is that people love their children, but they adore their grandchildren. And there's such a feel-good moment when they do some planning for grandchildren. You may have heard of dynasty trusts, which are a very powerful tool. You combine your gift tax exemption with your generation skipping tax exemption, and in certain jurisdictions, you can create perpetual trusts that are free from gift tax, estate tax, and generation skipping tax in perpetuity. It creates the level of wealth that the titans of industry in the beginning of the 20th century created for their dynastic clans. Let's go to page 21, please. Now, as we consider the burgeoning decision tree, let's spend a few minutes on the third potential use and distinction of wealth: assets earmarked for charity, especially that charity nearest and dearest to us, Davidson College. Gifts to charity are made out of a desire to support causes that are aligned with your values. And they also are motivated because you get a tax benefit to them when you make the gift. For lifetime gifts, taxpayers who itemize deductions on their income tax return deduct gifts to Davidson up to various limits against their adjusted gross income. Let's go to the next slide, page, please. Oh, we're on it, page 22, sorry. Let's go back one. Yes, thank you. The requirements for deductibility are as follows, but not all inclusive. The asset has to be paid or used for a qualified charity. It has to be purely donative in nature. It's not a payment for goods or services. It has to consist of either cash or qualified property. And it must not exceed income percentage limitations on adjusted gross income. There is a 5-year carry forward for charitable deductions. If you are limited in your adjusted gross income deduction in a given year, you've got 5 years to use the extra charitable deduction that you can take. The amount you deduct is the fair market value of the asset on the day you donate it. And we're going to look at a table of deadlines in a few minutes. However, pay attention closely to the cost basis of your asset. If it's a short-term capital gain asset, an asset that you've held for 365 days or less, you are limited in the amount you can deduct to your cost basis in the asset, not the fair market value. So you want to use long-term capital gains tax assets for gifts to charity. So those shares of stock that were $100 that you paid for it and they're now worth $1,000, and when you give it to a person, they inherit that limited cost basis. When you give it to Davidson, you, one, get a charitable deduction, you don't pay any capital gains, and Davidson inherits receives 100% of the fair market value, and Davidson, because it's a not-for-profit, does not pay the capital gains tax. So that low basis stock that so many people have because of this 10-year bull market is the perfect asset to donate. If you're contemplating donating tangible property to Davidson, remember that there's something called a related use rule. So it should be donated specifically to the gallery, not just for Davidson's unlimited use. Let's go to the next slide, please. It's important to note that any qualified charitable gift in your will or revocable trust is going to be deductible against estate tax. If you name Davidson as a beneficiary of your IRA, there will be no income tax imposed, and your estate is going to receive an estate tax deduction. This is after the passing of the surviving spouse. Other aspects of IRAs and charity. For individuals 70 and a half years old, you can make a tax-free charitable donation from your IRA as a qualified charitable distribution. It's $105,000 in 2024. The money has to go directly from your IRA to Davidson. Generally, the distribution is not taxable to you, and it doesn't count to your gross income. If someone is 73 or older, those qualified charitable distributions can count against the required minimum distributions that you are required to take. There's no charitable deduction for these amounts because you're not taking these distributions into income. Let's go to slide 24, please. So this is the slide that I referenced about the deduction limits on adjusted gross income. We're going to be sharing these slides with you afterwards, so this could be a good cheat sheet for you. And let's go to the next slide, and our last slide. I'm sorry, page 26. Thank you. This is your other cheat sheet, and this is super important. Keep track of your deadlines. Please don't wait till December 30th to make these gifts. The time of year is now. It's ideal to start working with your financial advisors and your accountants to review tax loss harvesting opportunities and charitable gifting strategies. Well, we've gone from discussing the importance from having a non-ambiguous expression of your intention for your wealth and personal health to understanding the tools and processes available to you to control the destiny of your wealth, how it's administered, who is in control, and the details and deadlines for implementation. Your commitment to the finalization of this process is going to enable you to control outcomes and ensure that your intentions and values are effectuated and met. And it's really been a pleasure to be here talking to you all. And I'd like to turn it over to Jamie.
Joanne, thank you so much. I can tell by the questions coming in that you've really gotten the gears turning for all of our attendees. So with the few minutes that we have left, let's turn over to some of those questions. So let's start with this one. Do you recommend making the same individual both the trustee of your trust as well as your executor, or should those be separate people?
They can be the same. It depends on their competency. It depends on your relationship with them. It depends on how you evaluate their ability to do both. But make sure you've got a successor named in case that person is unable to fulfill their responsibilities.
Okay, great. So this next question, I think, goes back to the more in-depth kind of conversation about the trusts. Why are joint revocable trusts only recommended in community property states?
So this is a little bit beyond my wheelhouse because I am a New York lawyer, and New York is not a community property state. So I would love to answer that, but I don't feel I can give a good, complete, and accurate answer.
That's totally fair, and we appreciate your honesty for that. So, and I think another question that's really broadly speaking to several people on the questions is, given that personal circumstances change, family dynamics change over time, how often do you recommend that individuals review and update their will or trust? And are there specific life events that should prompt an immediate review?
I think that is a great question. A lot of people say, okay, I'm done. You know, they basically put it in the virtual drawer and they forget about it. Milestone events are really important, and you have to align your wealth timeline with when you review things. One, if your wealth changes dramatically, you have a windfall, or there's a reversal of fortune, you should look. When there are milestones, when children get married, when grandchildren are born, you should review it again. When you retire, you should review it again. And certainly when there are sweeping changes in the tax law, that requires review, or when your state and local laws might change, you should have that reviewed. And if the people you have entrusted to serve as executor and trustee are not available anymore, you've got to go back to the drawing board.
So along the same vein, do you need to review or alter your estate plans when you move to a different state?
Yes, you should. So New York is like an amazing place because people become snowbirds. They leave New York and they go to Florida because Florida has no state income tax and no state estate tax. And so what we tell people is you better get a Florida lawyer, change your domicile, change where you vote, change where your cars are registered so that you can get all those advantages, but you have to understand that there are state-specific things that need to be included in your documents. And so whether it's Florida or any other state, you absolutely should have that all reviewed.
That's very helpful. What are some common mistakes that people make when they're creating their will or their trust, and how can those be avoided?
Okay, I'm going to give you my personal bias. They leave money outright to children too soon. I have seen so many trusts where at age 21, all the trusts end and the children inherit the wealth. My personal bias is if you want children to receive wealth outright, start it at a later age. Do not require that income be paid. That is a big mistake, because if you require that income be paid from a trust, it can become subject to the claims of creditors. If the trustee has discretion to pay income according to a certain standard or, suggestions, then that income stream is protected from creditors. So one is age. Be careful about outright distributions at certain ages, and be careful about requiring income to be paid. My bias is lifetime trusts, because the trustee can have broad discretion to make principal distributions for certain reasons. They can also purchase homes in the names of the trust so that the children can live in the home, but the house is asset protected. So trust can be vehicles of great flexibility.
So one last question, and I think this is just probably the most basic thing that's on a lot of people's mind, is where do you get started? I mean, what are the most essential first steps that any person should think about when it comes to estate planning?
The first thing you start with is a conversation with the other person in your life who's going to be a decision maker. Whether it's your life partner, whether it's your spouse, whether you don't have a spouse and you want to talk to your adult children about your intentions, that's the first thing, is discussing and coming up with a really clear expression of what your intentions are. Then you hire an attorney and work with that attorney to develop a plan that unambiguously expresses your intentions well within tax optimization and creditor protection issues. And remember, every family is different. And sometimes you'll have a special needs child that needs a special trust that's written in a way, or there may be a person who's vulnerable, or there may be substance abuse issues. These are ways that you can continue to benefit people, but protect them from the vulnerabilities that keep you up at night.
Well, great. Well, thank you so much, Joanne. Just once again, a huge, huge thank you on behalf of Women Act and the Office of Gift Planning. This has been incredibly helpful to so many of our attendees, and we're so grateful to have you as a new member of the Davidson community. So on behalf of Women Act and the Office of Gift Planning, we'd like to thank all of you for joining us this evening. We hope that you found this session to be beneficial, and that you're walking away with ideas and inspiration on how you can go about your own estate planning process. Please remember that the Office of Gift Planning here at Davidson is here to serve as a resource as you go through this process and think about the philanthropic aspects of your estate plan. In our follow-up message, as a reminder, we will be sure to include not only tonight's presentation, but our online resources and contact information as well, so that if there's anything we can do to assist you, you know how to get in touch with us. With that said, we hope you all have a wonderful evening, and we look forward to hosting future events for women in the future. Thank you all, and have a lovely night.